Picture a courtroom, the flag, the seal, the elevated bench, the robe. Everything in that room is designed, architecturally, ritually, institutionally, to signal one thing, that what happens inside these walls is different from what happens on the street, that this space operates by rules, that justice here is not bought, not negotiated, not auctioned off between the bailiff's coffee break and the lunch recess. Now imagine that every single one of those signals was a lie. In the early 1980s, the FBI received a complaint from a young assistant state's attorney in Chicago. His name was Terrence Hake. He wasn't reporting a single dirty judge, a single bad cop, a single bent lawyer. He was describing a system, a functioning, organized, daily operating system of bribery, embedded inside the Cook County Circuit Court, one of the largest court systems in the United States. Cases were being fixed, not occasionally, routinely. Judges were accepting cash payments to dismiss drunk driving charges, reduce felonies, and in at least some instances determine the outcomes of violent criminal cases. Attorneys knew who to pay and how much. Police officers participated as bagmen and fixers, and the whole arrangement moved with the quiet efficiency of something that had been running long enough to stop feeling criminal. The FBI didn't just open a file, they sent a man in. For 3.5 years, Terrence Hake wore a wire inside that court system. First as a prosecutor, then as a defense attorney, recording more than 1,500 conversations with judges, lawyers, cops, and clerks who had no idea the person handing them a bribe was working for the federal government. By the time it was over, 93 people had been indicted. 17 of them were judges. But here's the question that doesn't go away, the question that this investigation quietly raised and never fully answered. If the judges who were supposed to guarantee due process were themselves corrupt, how many verdicts delivered in those courtrooms, guilty or not guilty, were actually just? That is the question at the center of everything that follows. Chicago, 1980. To understand what was about to be uncovered, you first have to understand the machine. The Cook County Circuit Court was not a small operation. It was, and remains, one of the largest unified court systems in the United States, processing hundreds of thousands of cases each year across dozens of courtrooms spread through the city and its suburbs. Traffic violations, drug arrests, robberies, sexual assaults, murders. Everything fed into the same system. Everything, in theory, passed through the same blind scales. In practice, the scales had a price list. The FBI had been hearing rumors about Cook County's judiciary for years before they ever made a move. As early as 1975, agents running a routine wiretap on a gambling operation overheard something that stopped them cold. An attorney, casually, braggingly, told the gamblers that if they ever got arrested, they had nothing to worry about. He could pay Cook County judges to make the charges disappear. The Bureau developed that attorney as a confidential source. He agreed, at least in principle, to wear a wire. But when the time came to record a judge or a fellow attorney, there was always an excuse. He was never willing to actually wire up. The FBI had a thread, but no one to pull it. That changed in 1980, when State's Attorney Bernard Carey, himself a former FBI agent, mentioned to Bureau officials that one of his young prosecutors had been complaining loudly about what he was seeing inside the courts. His name was Terrence Hake. He was 28 years old. He'd been a lawyer for roughly 3 years. Hake was not naive. From his first day as a prosecutor moving through Chicago's misdemeanor courts, he had heard the rumors. Defense attorneys paying off judges, cases evaporating despite airtight evidence. But rumors and certainty are different things. What hardened Hake's suspicion into something he could no longer dismiss was simpler and more brutal than any single dramatic moment. He kept losing cases he should have won. Defendants walked free in front of judges even when the evidence was overwhelming in the state's favor. There was no logical explanation. The pattern was too consistent, too clean. He was eventually transferred to the murder, rape, and child molestation preliminary hearing courtroom at the main criminal courthouse, one of the most serious divisions in the entire system. And there the corruption was not subtle. Rumor had it that if bailiff Lucius Robinson sat in the jury box during a preliminary hearing, it was a signal. Robinson had already collected a bribe from the defense attorney, and the judge, Maurice Pompey, could proceed to dismiss the case. Hake watched. He never personally observed Robinson use the jury box as a signal during his 3 months in that courtroom. But what he did observe convinced him enough to take the complaint all the way up the chain. It is worth pausing here to consider what kind of person makes that choice. Hake was told directly, before he ever agreed to cooperate, that if he participated in the FBI operation, he would likely never practice law in Cook County again. The lead federal prosecutor told him the same thing. If he made cases on lawyers and judges, Cook County was effectively closed to him professionally. He agreed anyway, but no investigation begins with a hero. It begins with a system that made the hero necessary. That system had been building for a long time, and the FBI was not operating without precedent when they finally committed to going inside it. The most chilling data point, the case that clarified, more than any rumor, just how far the rot had spread, was not a drunk driving dismissal or a dismissed drug charge. It was a murder. On the night of September 27, 1972, a Union truck dispatcher named William Logan stepped out of his home on his way to work. From the shadows, a voice called out, "Hey, Billy." When Logan turned, he was cut down by 3 shotgun blasts. A neighbor walking a dog saw the gunman heading toward a waiting car. A woman on the phone caught a glimpse of his face through a window. She recognized him. His name was Harry Aleman, a man already known to law enforcement as a killer connected to the Chicago organized crime outfit. Aleman was charged with the murder. The case went to a bench trial, meaning a judge, not a jury, would decide the verdict. The judge who presided had a reputation for finding defendants guilty in bench trials. This time, despite the eyewitness testimony, he found Harry Aleman not guilty. The FBI would not learn for years that the verdict had been purchased for $10,000. But even in 1972, something about that acquittal didn't sit right. By 1980, the Bureau had enough fragments to understand the shape of what they were looking at. Not a few bad actors, not isolated incidents of judicial misconduct. A functioning, organized network, one in which judges, attorneys, police officers, and court clerks had collectively decided that the law was a transaction, not a principle. The only question was how deep it went. And the only way to answer that question was to go inside. The FBI named it Operation Greylord, after the curly gray wigs worn by British judges. Whether that was irony or coincidence, no one said publicly. But the name carried a kind of dark poetry. Authority as costume, justice as theater. The operational plan was unlike anything the Bureau had attempted inside an American courthouse before. They would not surveil from the outside. They would not trace money after the fact. They would not flip a low-level clerk and hope the thread ran high enough. They would go inside the machine, move through it, and let it corrupt them. I'd say, on tape. The first phase began in late 1980. Hake was still working as an assistant state's attorney. His assignment was deceptively simple. Act like the attorneys around him. Accept the culture. Learn the informal rules. Pay attention to who approached whom, how money changed hands, what language was used to signal a case was fixed. He was not yet paying bribes. He was learning the grammar of corruption. And the grammar was specific. In Chicago's misdemeanor courts, the drunk driving courts, the minor drug courts, the traffic courts that processed hundreds of defendants a week, the system operated through middlemen. Defense attorneys didn't walk up to a judge and hand over an envelope. There were layers. A defense attorney with a case to fix would approach a fixer, typically another attorney who had established relationships with court personnel, and pay them a fee above the normal legal rate. The fixer would then pass a portion to a bagman, often a deputy sheriff or a court clerk, who would in turn deliver the bribe to the judge. The whole chain was built on deniability at every link. Cash moved in hallways, in men's rooms, in the small side rooms judges used for private conversations. It was, by any reasonable account, organized. Not chaotic or desperate, organized. The participants had internalized the arrangement so thoroughly that they no longer experienced it as criminal activity. It had become, for them, simply the way cases were resolved. Hake began recording. In 1981, the FBI took a step that had no precedent in American legal history. After reviewing tapes recorded by Hake, a federal court found sufficient probable cause and authorized the Bureau to plant a listening device inside the chambers of an active sitting judge. The judge was Wayne Olson, who presided over a narcotics courtroom. The bug went in. The conversations that followed confirmed what Hake's recordings had already begun to suggest: that the corruption was not incidental, it was structural. Meanwhile, the operation expanded. 2 other attorneys agreed to operate undercover alongside Hake. A downstate judge named Brockton Lockwood went undercover in Chicago's traffic court. Cook County Judge Thaddeus Kowalski cooperated with authorities, knowing that his cooperation could end his career. The FBI was building a network inside a network. To generate evidence suitable for federal prosecution, investigators did something that would later become one of the most legally scrutinized aspects of the operation. They manufactured fake cases, real court proceedings with real paperwork involving fake defendants and fabricated crimes, staged specifically so that the undercover attorneys could offer bribes to corrupt judges and document the transactions. The scheme worked because it was indistinguishable from the outside from any other Cook County case moving through the system. It worked, that is, until it didn't. The undercover phase ended not with a dramatic confrontation or a whistleblower, but with the kind of mishap that could only happen in the particular surreal theater of a sustained undercover operation. One of the fake victims in a contrived case accidentally dropped his FBI badge. A Chicago beat cop noticed. The investigation was immediately exposed. The Bureau shifted into the arrest and prosecution phase. Between 1983 and the early 1990s, indictments rolled out in waves. The first defendant convicted was Harold Kahn, a deputy traffic court clerk, one of the bagmen in the network, found guilty in March 1984. He was, in the hierarchy of the scheme, a small figure, but his conviction established that the federal government had the evidence, the testimony, and the will to dismantle the network from the bottom up. The numbers that followed were staggering. 93 people indicted, 17 judges, 48 attorneys, 10 deputy sheriffs, 8 police officers, 8 court officials, and 1 state legislator. But the number that kept returning in every subsequent analysis of what Operation Greylord meant was not 93. It was the number of cases, criminal cases involving real defendants, real victims, real consequences, that had moved through those courtrooms while the bribery system was operational. By the time the FBI walked out of Cook County with its tapes and its files and its list of the corrupt, no one had a clear answer to a question that should have been the first one asked: how many people were convicted or acquitted, not because the evidence demanded it, but because someone had paid for the outcome. That question would follow every subsequent indictment, every trial, every sentencing, like a shadow that never quite resolved into a shape. The tapes were the foundation, but what made Operation Greylord genuinely unprecedented, and what made it genuinely dangerous for the Bureau, was not just the quantity of recordings, but what the recordings revealed about the architecture of corruption inside Cook County's courts. Start with the bug in Judge Wayne Olson's chambers. On November 26, 1980, the United States Attorney filed a formal application to intercept the oral communications taking place inside those chambers. A federal judge reviewed Hake's recordings, conversations already captured, already establishing probable cause, and authorized the device. The bug went in. What it captured over the following months was not the guarded, coded language of men who feared exposure. It was something more disturbing: casual conversation. On tape, Judge Olson was recorded stating that he liked people who took money because you know where they stand. This was not a man operating under the pressure of a compromised moment. This was a man who had arranged his entire professional worldview around the assumption that corruption was simply a more honest form of how things actually worked. He was not conflicted, he was comfortable. That comfort was, in retrospect, the most important thing the tapes documented. Not the transactions, but the absence of shame around them. The investigation confirmed that the bribery network operated in distinct tiers, and the evidence against each tier carried different weight. At the bottom were the bagmen, deputy sheriffs, court clerks, and courthouse fixtures who moved cash between attorneys and judges. One of the most detailed pictures of this tier came from bailiff Lucius Robinson, who ultimately admitted to delivering over 200 bribes to Judge Maurice Pompey. Though Robinson's admission came after the statute of limitations had expired, meaning Pompey himself could not be prosecuted for those specific acts. This was the first of many structural gaps in the evidentiary picture that the investigation would produce. Above the bagmen were the fixers.
We'll count it immediately.
Attorneys who functioned as intermediaries, soliciting cases in courthouse hallways and routing bribe money upward. The most elaborately documented example was Judge Richard Lefevre, former chief judge of traffic court, who ran what investigators would later describe as a hustler's bribery club, an organized network of attorneys who paid Lefevre $2,500 per month for the right to solicit clients in the courthouse hallways. Lefevre's cousin, Jimmy, served as his bagman and primary conduit for payments. The scale of the operation was established not through a single dramatic transaction, but through financial forensics. Prosecutors produced charts tracking Lefevre's income and expenditures over a 5-year span, demonstrating that he had disbursed $143,000, more than could be accounted for through any legitimate source. The question posed at trial was direct. Where did the money come from? The prosecution's answer: bribes. Lefevre was ultimately convicted on 59 counts of mail fraud, racketeering, and income tax violations, and sentenced to 12 years in prison. But the case that clarified most sharply what was actually at stake, beyond the corruption of individual courtrooms, was not Lefevre's. It was the case of a man who had never been charged within Operation Greylord's formal scope at all. Harry Aleman had been tried for the 1972 murder of Union official William Logan in a bench trial before Judge Frank Wilson. In 1977, Wilson acquitted him. The acquittal had been suspicious from the moment it was rendered. The eyewitness testimony was credible. The circumstantial evidence was strong. But an acquittal is an acquittal, and the double jeopardy clause of the Fifth Amendment is not ambiguous. No person shall be tried twice for the same offense. Operation Greylord produced evidence that changed the legal meaning of that acquittal entirely. Investigators concluded that Judge Wilson had accepted a $10,000 bribe from organized crime figures connected to Aleman in exchange for the not guilty verdict. Wilson himself never faced trial. He died before charges could be filed. But the question his case raised was constitutional in the most literal sense. If the first trial was a purchase fiction, if there was never any genuine risk of conviction because the outcome had been pre-decided, had Harry Aleman ever actually been in jeopardy in the legal sense? The Illinois Appellate Court, and ultimately the United States Supreme Court, concluded that he had not. The double jeopardy clause, the court held, does not attach to proceedings infected with fraud and collusion. Because Aleman had bribed his way to an acquittal, he had never faced real jeopardy in the first place, and could therefore be tried again. This ruling was not a narrow procedural footnote. It was a statement about what corruption does to the foundational structures of law. A bribed acquittal is not an acquittal. A fixed verdict is not a verdict. The entire constitutional architecture protecting defendants from being tried twice for the same crime rests on the premise that the first trial was real. At Cook County, for years, many of them were not. This is where the investigation's most significant and unresolved evidentiary problem came into focus. The FBI had built its case against judges and attorneys through Hake's recordings, financial forensics, and the cooperation of insiders, most notably Judge Thaddeus Kowalski and Judge Brockton Lockwood, who had gone undercover in traffic court. The evidence against the individuals charged was, by most accounts, overwhelming. 15 of the 17 indicted judges were convicted. 83 people in total were ultimately found guilty across the full span of the investigation. But the investigation had been designed to catch the corrupt. It had not been designed, and perhaps could not have been designed, to identify every case those corrupt officials had fixed. The FBI knew who had taken bribes. They could not reliably reconstruct which specific verdicts those bribes had purchased. One attorney who cooperated with prosecutors stated that he had paid bribes to 24 different judges who had sat in traffic court. The same attorney estimated he had paid one judge, a single judge, 200 to 300 times in connection with mostly drunk driving cases. Each of those payments represented a defendant whose case had been decided not on evidence, but on cash. Some of those defendants were guilty. Some, statistically, were not. The investigation had no mechanism to distinguish between them. 3 of the judges indicted in the Greylord network died before they could be brought to trial. 2 of them died by suicide. Their deaths closed certain evidentiary lines permanently. And then there was the question of scope. In 1991, 3 years after the Greylord indictments had been made public, and years after prosecutors had announced the investigation's conclusion, federal authorities charged a 20th judge, then a 21st. The U.S. attorney at the time, when asked whether the recent charges suggested that Operation Greylord had failed to substantially deter judicial corruption, offered no argument to the contrary. "I think the results of the past week," he said, "speak for themselves." The investigation had been historic in scale, but the system it had tried to dismantle had shown, in the years immediately following, that it was capable of regenerating, not as quickly, not as openly, but enough to raise a harder question than the one the FBI had originally set out to answer. The question was no longer simply, who was corrupt? It had become, how much of the damage was permanent, and how much of it was invisible. A federal courtroom in Chicago, 1985. 8 weeks of testimony, 140 witnesses, 59 separate counts. And at the center of all of it, a man who had been called the architect of corruption inside Cook County's courts, sitting silently at the defense table, refusing to take the stand. Richard Lefevre did not testify in his own defense. The government's theory, laid out by Special U.S. Attorney Dan Webb in opening arguments, was straightforward but devastating in its specifics. For 14 years, Lefevre had run a bribery operation inside traffic court and municipal court with the organized efficiency of a business. Attorneys paid a flat rate, initially $100 per case, later escalating, for the guarantee that drunk driving charges would be reduced, licenses preserved, inconvenient prosecutions quietly dismissed. The money moved through his cousin, Jimmy Lefevre, who served as bagman. The judge himself kept enough distance from the cash to maintain plausible deniability, but federal prosecutors had solved that problem the old-fashioned way. They followed the money. The government presented financial charts demonstrating that between 1974 and 1979 alone, Lefevre had dispersed $143,000, more than he had received through any documented legitimate source. No inheritance, no investments, no explanation. Only one inference remained. Lefevre's defense team offered an alternative theory, and it deserves a fair hearing because it was not entirely implausible on its surface. The defense argued that Lefevre's bagmen, the very men testifying against him, were themselves running a private shakedown operation. They had approached parking violators and drunk driving defendants. The defense contended, collected cash for themselves, and then approached Lefevre to dismiss the charges, knowing that the judge had a liberal practice of granting dismissals on request for unrelated reasons. Lefevre, the argument went, was an unusually lenient judge who happened to have corrupt subordinates. He had never personally accepted a bribe. It was a coherent theory. The jury deliberated for less than a day. The forewoman stood and read the verdict. Guilty on all 59 counts. Lefevre sat back, glanced at his wife, and shrugged. Special Prosecutor Webb told reporters afterward that in his opinion, Lefevre's conviction represented the peak achievement of the entire Greylord investigation. One juror, walking out of the courthouse, had no interest in nuance. There was never any uncertainty, she said. Lefevre was sentenced to 12 years in federal prison. 3 months after Lefevre's conviction, Judge Wayne Olson stood before U.S. District Judge Stanley Roskowski for sentencing. Olson had already pleaded guilty. He was not fighting the charges. He was pleading for mercy. In a statement that the courtroom sat quietly through, Olson said, "I must begin by expressing my apologies to you, to all the judges, and to all the lawyers for the disgrace I have caused. I have spent 800 sleepless nights. I have replayed this in my mind countless times, seeking peace to understand my actions. Judge Roszkowski sentenced him to 12 years in prison and a $35,000 fine. His response was direct. I am a judge. This is a case that demands a severe penalty. The recordings from Olson's own chambers, 250 hours of them played in court, had left no room for argument. But the trial that reached furthest into the meaning of Operation Greylord was not a federal prosecution under the Greylord indictments at all. It was a state murder trial that happened 2 decades after the crime, in a Cook County courtroom not far from where the original corruption had taken place. Harry Aleman had been acquitted of the 1972 murder of William Logan in a bench trial before Judge Frank Wilson. He had lived with that acquittal for 20 years. When prosecutors moved to retry him in 1993, based on evidence that the original acquittal had been purchased for $10,000, his defense attorney was immediately in court. This was double jeopardy. The Fifth Amendment, the most fundamental protection in criminal law. The courts disagreed. The Illinois Appellate Court and then the Seventh Circuit Federal Court of Appeals both held that Aleman had never faced genuine legal jeopardy in 1977. Because the outcome of his first trial had been prearranged, the verdict was purchased before it was rendered. A corrupt acquittal is, in legal terms, a nullity, not an outcome, but a transaction. The double jeopardy clause does not shield a man from the consequence of a trial he had secretly bought. Aleman's defense called this reasoning circular and dangerous. If the government can declare a verdict void whenever it claims the trial was corrupt, what remains of the protection against double jeopardy? Where is the line between correcting a specific injustice and creating a mechanism for endless reprosecution? These were not frivolous questions. They were not resolved cleanly by the court's answers. The second trial proceeded. In 1997, a Cook County jury, this time a jury, not a single judge, convicted Harry Aleman of the murder of William Logan. He was sentenced to 100 to 300 years in state prison. He died there in 2010. He became, in the legal record, the first American ever retried for murder, following a fraudulent acquittal at the original trial. The verdict felt, on its surface, like justice arriving late but arriving complete. But the question that Aleman's defense had raised in court, quietly, technically, without the dramatic weight it deserved, continued to sit in the record like an unresolved chord. If the premise of a second trial is that the first verdict was void, then the evidentiary standard for nullifying a verdict must be exceptionally high. In Aleman's case, the evidence of bribery was strong, but the doctrine established by his case made no formal requirement that it be that strong. It established only that it needed to be sufficient, and in Cook County, in the 1980s, the definition of sufficient had been a negotiable commodity for years. In August 1984, before the last Greylord indictments had even been filed, the Illinois Supreme Court assembled a 43-member special commission on the administration of justice in Cook County. Its assignment was straightforward in language, if not in execution. Recommend changes to prevent this from happening again, and restore public confidence in a court system that had just been revealed as, in substantial part, a criminal enterprise. The commission worked for 4 years. It produced 195 formal proposals. Some were structural, changes to how cases were assigned to judges, specifically to eliminate the informal arrangements that had allowed attorneys to seek out sympathetic courtrooms. Some were financial, higher judicial salaries, on the theory that better compensated judges were less susceptible to the incremental corruption that begins with small compromises and ends with hundreds of transactions. Some addressed transparency, public disclosure requirements, ethics training, clearer reporting mechanisms for attorneys who witnessed misconduct. The reforms were real. The improvements were documented. Former prosecutors who had worked the Greylord cases went on to careers in large law firms and, in at least one case, on the bench itself. Candace Fabry, who had been part of the prosecution team, became a Cook County judge in 2006 and was rated well qualified by a local attorneys group. Terrence Hake testified in 23 separate trials over the 10 years following the Undercover operation, and later wrote a book about what he had witnessed and done. He had been told before the operation began that he would never practice law in Cook County again. He walked away from the investigation, it seems, understanding that what he had given up was simply what the work had cost. The stiffest sentence handed down by any Greylord-related prosecution belonged to Judge Reginald Holzer, 18 years in federal prison for accepting over $200,000 in bribes from multiple attorneys. The prosecutor who tried him was a young assistant U.S. attorney named Scott Turow, who later left government service and became one of the most celebrated legal novelists in America. His experience inside Operation Greylord gave him, he has said, a perspective on the American justice system that no law school could have provided. But the clearest measure of Operation Greylord's limitations was not found inside any courtroom. It was found in the years that followed. In 1991, 3 years after the investigation had been formally declared concluded, federal prosecutors charged a 20th Cook County judge with corruption. Then a 21st. New investigations followed, bearing new names: Operation Silver Shovel, Operation Gambat, Operation Lantern, Operation Safe Bet, each targeting different layers of the same persistent culture of institutional corruption that had grown around Chicago's courts and political structures for decades. Greylord had removed specific actors. It had altered specific procedures. But the soil that had produced the corruption, the patronage networks, the judicial election financing, the informal cultures in which access and outcomes were quietly traded, had not been removed. There is a conclusion that the record of Operation Greylord almost invites, and it is worth resisting, that the investigation was a success. The corruption was cleaned up, and the system emerged stronger and more just. That narrative is too clean. The 83 convictions were real. The deterrent effect was real, at least for a time. The Commission's reforms were substantive. But the question that the investigation posed without fully answering, how many verdicts in those years were determined by cash rather than evidence, was never seriously computed. And the cases that may have been corrupted were not systematically reviewed. The people who passed through those courtrooms during the years the bribery network was operational were not offered a formal process for revisiting their outcomes. Some of them were guilty. Some, by the laws of probability, were not. The law has no clean mechanism for handling that reality. Double jeopardy only works in one direction, and it is the direction that protects defendants from the state, not defendants from corruption they never knew existed. Operation Greylord is described today as the longest and most successful undercover investigation into courtroom misconduct in American history. That is an accurate statement. It is also, read carefully, a statement about American history, not a statement about Cook County justice. When Terrence Hake was recruited into the FBI's operation in 1980, he had already spent years watching defendants walk free in front of judges who had already decided the outcome. He had watched the machinery of justice produce results that bore no relationship to the evidence. He had complained. He had been reassigned, and then he had agreed to go in wearing a wire, knowing it would cost him his career, in the place where he had chosen to work. Years later, asked about what the investigation had ultimately achieved, he did not use the word justice. He described it as removing people who should not have been there. That is a narrower claim than the one the history books tend to make about Operation Greylord, but it may be the more honest one. In the end, the courtroom remains exactly what it has always been, a room in which human beings, with all their vulnerabilities and appetites, are asked to perform the function of dispassionate judgment. When that function operates as intended, it is one of the more remarkable things a civilization produces. When it does not, when the robe becomes a costume and the seal becomes a prop, the damage does not announce itself. It accumulates quietly, verdict by verdict, until a young prosecutor with 3 years of experience and a growing sense of dread decides he cannot remain silent. The question Operation Greylord left behind is not whether justice was served in those courtrooms. We know enough now to say it was not consistently, not reliably, not for every defendant who passed through. The question is more uncomfortable than that. How many rooms like it are we not watching closely enough right now?